Hey, good afternoon and welcome everybody on behalf of the Center for Civil and Human Rights and the Kellogg Institute for International Studies. It's really a privilege. Oh yeah, come. We had another chair for you. We're going to be a little crowded around here, but okay, we have. That's great. Thank you. As I said, it's a real privilege to be introducing this extraordinary group of people to you. We have been having a little conversation, a retreat here for the last day and a half about, as you see, the future of the inter-American system of human rights, a system that has been around and a significant actor within international law and human rights in this hemisphere for well over 50 years, since 1959 was the first establishment of the Inter-American Commission on Human Rights. The court has been around for about 35 years now in a system whose first normative instruments date to 1948, even before the Universal Declaration of Human Rights. It's a system that has had an enormous impact in the region. It acquired a great deal of political capital and legitimacy in great times of crisis in human rights in the hemisphere. And so a system that is certainly not one that is new or to be taken lightly. And yet, at the same time, one that is been the subject of a great deal of debate in recent years about the need for reform. In what ways does it fall short of its promise? In what ways can it be even better? So we at the Center for Civil and Human Rights decided that Notre Dame could play a distinctive role in that conversation by convening here a distinguished group of people representing all sorts of different backgrounds, some academics, some from the NGO activist communities, people with political experience in their governments, people who had been judges and commissioners and advocates within the institutions of the system. And we've had a very, very rich conversation behind closed doors for the last day and a half, dealing with themes such as the challenges that are facing the processing of contentious cases in the inter-American system, the ways in which judges and commissioners are selected and appointed, and some of the difficulties that are faced in that process, the way in which the international institutions of the human rights system relate to domestic legal systems, and in particular domestic courts, and the challenges posed by the practical distinctions in the region between countries of the North and South, if you will, or countries of the English-speaking world and other languages of this hemisphere. These were just four of the themes that we could have discussed. We had to be limited because of the amount of time. But there are many other themes as well that people identify as being important challenges to the system. One of the things that unites everybody who participated in this retreat is that, despite all of their backgrounds and different paths that they trod, what we all share, is a strong commitment to the future of the inter-American system, to seeing it flourish, to being strong, and to contributing to the common good of the entire hemisphere. So what I've asked our guests here to do, this is only a portion of those who were with us for a day and a half. Many of them had to leave after our session this morning. But those who could remain, what I've asked them to do for you is to answer just one small and simple question. That question is, what, in their view, in your view, is the single greatest challenge facing the inter-American system today, and what, realistically, would you do about it if you could? And I've asked them to limit their remarks in virtue of the numbers, but also to keep this dynamic, flowing kind of conversation with you, to only 3 minutes in their responses. Okay? Flash panel writ large. The only exception will be one of our guests who will need translation, and we'll give them a little thinking time along the way. So without further ado, let me introduce I'm not going to translate from French for you, sorry. Let me introduce the members of our panel, our distinguished panel here. I'll just go in alphabetical order and hope I didn't miss anybody here. To my immediate left, Professor Laurence Burgaud-Larsen from the Sorbonne School of Law in France, the only member of our group who is not from the Americas, but who is, for a very long time, been one of the most distinguished scholars in Europe of the inter-American system and of Latin America and human rights questions more generally. Bernard Duhaime, professor from the University of Quebec in Montreal, and a graduate of this law school. Judge Sergio García Ramírez, now professor at the Instituto de Investigaciones Jurídicas of the Universidad Autónoma of Mexico and former judge and president of the Inter-American Court of Human Rights. Ambassador Joel Hernández García, formerly a permanent representative of Mexico to the Organization of American States, a long-time leader of the discussions in these areas of reform, currently president of the Mexican Foreign Service Commission. Viviana Kristisevich, executive director of CEGIL, the Center for Justice and International Law, by far the most important NGO litigating in the inter-American system. Helen Mack, president of the Myrna Mack Foundation in Guatemala, a very important foundation for the advocacy of human rights, not only in Guatemala, but throughout the hemisphere and the fight against impunity in particular. Judge Margaret May Macaulay, attorney at law from Jamaica, but also a former judge of the Inter-American Court of Human Rights. And Katia Salazar, the executive director of the Due Process of Law Foundation in Washington, D.C. I don't think I've omitted anybody. So, rather than spend more of the time on introductions, let's start. 3 minutes, greatest challenge, and what would you do about it? Bernard, I regret that you ended up sitting on my far left, because it means you have to go first. But, it's like being in the classroom at Notre Dame again, so why don't you just get us started for your successors in these seats. You can stay seated right there if you'd like. If you'd like a microphone, this one works.
Sure. I have a small...
Just let me make sure I get it on here. There we go.
Merci beaucoup. Thank you very much. It's an honor to be back. I'm very, very glad to be back in Notre Dame. It's my second home. It's a privilege to be sitting at the same table as all these distinguished speakers. And I thank everybody for this opportunity. We've talked about several institutional challenges in the past 2 days in our discussions. I would like to talk now about a substantive law issue that I think is central in the challenges that the system faces, and more broadly that the Americas face with regards to respecting human rights, and it's the one of exclusion, marginalization, and discrimination more specifically. I think our continent has a long history of discrimination, going back to the exclusion and extermination to some extent of the indigenous peoples, the history of slavery, and the permanent existence of situations of discrimination. So I think it's really a transversal issue that faces victims of human rights violations in the continent, and in particular, of course, people, persons and groups facing situations of vulnerability, women, children, indigenous peoples, migrants who should, in my sense, benefit from the special protections that international standards grant to them. And if I would go further, I think one of the difficulties that we will face in the next years, and the challenge really that we have to surmount, is that in the intersection of discriminations. which is very different than the simple existence of two forms of discrimination, but try to identify how being victims of two forms of discrimination at the same time can create an additional, a third form of result which doesn't exist for people who don't face discrimination. So I often take the example of indigenous women. This is a problem that indigenous women face in Canada, very, very sensitive to this issue in my country. Being an indigenous person and being a woman, an indigenous women doesn't necessarily raise the same issues. There are lots of concerns for indigenous women that indigenous men don't face and that non-indigenous women, for example, do not face. And we have a challenge to try to construct tools to understand the specific nature of these intersections of discrimination and how to find solutions for that. And that's extremely difficult. I think the inter-American system is going the right way. It's developing a jurisprudence on these issues, in particular in the Cotton Fields case. It's been developing this approach, looking at structural discrimination as well. But we need to go further. We are adopting new instruments with regards to discrimination, in particular racial discrimination. We have other instruments with regards to women's rights or to children's rights. And we're also applying special protections coming from other normative sources, for example, the ILO Convention 169 or the UN Declaration on the Rights of Indigenous Peoples and so on. But I think we need to go further than recognize the application of these instruments and try to see how these special protections can work together to address the special result that the special consequences of the intersection of discriminations. And this is really a big challenge for lawyers, for activists, for judges, because this will continue to be present in our lives in the Americas for the years to come. That 3 minutes, please?
You're over time, sorry. Joel will show you what 3 minutes really is.
Well, for me, the biggest challenge is one of a structural nature. This has to do with the financing of the inter-American system. It's a so complex issue that it was not a matter of discussion in the retreat, and I'm happy that we didn't go very much into that detail because we would have gone nowhere. The fact is that both the Commission and the Inter-American Court are two bodies which are understaffed, and they have a big casework pending to be resolved. Without the necessary resources, for me, it's very difficult that we can have a viable system. Both the Commission and the Court are bodies of the Organization of American States. The organization itself has a very limited budget of $83 million US dollars. Most of the programs of the OAS are funded with voluntary contributions, amounting to about $150 million US dollars. But only for the Commission receives it has a budget of around $9 million US dollars. Half of it comes from the OAS regular budget, and the other half is made by voluntary contributions. The Commission has a docket of about 1,700 pending cases, and it only has a staff of about 30 lawyers. Much of the work is done by interns, and actually the Commission recruits interns from law schools, and I'm sure that this law school does provide a big number of interns in order to do their substantive work. If we don't give a special funding for the Commission, we don't change the rules under which now the Commission has been funded, for me it's very difficult that we can have a viable Commission for the future. There's not such a thing as a solution in the short term. We member states have made big efforts to address this issue. during the Special General Assembly in March, member states made a commitment to move towards full financing of the Commission by a regular budget, but that implies an increase in the contributions of member states to the organization, and we reach to that level. Nobody wants to see their contributions increased, or very few countries do accept some increase in their contribution, sometimes only to cover a cost of life increase or inflation cost, but it's been very difficult to go and get increases for substantive work of the organization, and of course for the Commission. What can we do about this? It's a very difficult question to answer. Now the organization is once again involved in a reflection process of what should be the strategic vision of the organization and how the organization can streamline its work in order to focus resources and efforts on key issues, including human rights. And this exercise should give a fresh report in the following months. And I'm sure that from that report, of course, the importance of human rights will arise. But that will not be sufficient just to focus the importance of human rights, because that has been done several times. What we need is to have a major political movement from major contributing countries in order to get a substantial increase for the organization of the Commission. The good thing about this, we can look at it from an optimistic point of view, is that 4 member states of the organization contribute up to 80% of the OAS budget. US, Canada, Brazil, and Mexico, in that order, are the major contributors to the organization. The contribution amount up to 80%. So I do hope that we could have some political willingness of at least this group of 4 major countries in order to really give a qualitative step forward in order to go into the real problem of the funding of the organization and the Commission, and from there making a new beginning with fresh resources which are very much in need for the Commission.
Good afternoon, everyone. I must admit it's a pleasure to be here. This is the first time I'm seeing your campus and stepping foot on it, and you have a beautiful campus, and I envy you. When I went to college, it was certainly nothing like this. I'm going to mention, mine is a twofold thing, which is procedural and has an effect in the substantive work of the court. And this is, one is how the judges of the court are nominated and elected and how the court is constituted. And secondly, it is the length of judgments of the court, because the persons who are on the court affect the length of judgments of the court. And presently, the court is made up of 7 gentlemen, all Latin gentlemen, who are rather nice fellows, and knowledgeable fellows, but they're not women. And there are no women on the panel of judges. Now, I think this is not a good thing at all, certainly not in this day and age. And there is, in fact, no procedural mechanism in place to ensure that when judges come up for nominations and elections, that there is a mix of the sexes in the first place, a mix of ethnicity, because the region, the Americas, is full of a mixture of different ethnic groups. And also expertise in various fields of law. And because there is presently a group of 7 Latin gentlemen, there is no common law lawyer there. So there should be, in my view, also at least, I think, 2 common law lawyers on the bench of the court. And in that way, one can ensure that judgments are shorter than they normally are when it's a panel of my Latin brothers only, or a mix of Latin brothers and sisters, because from my experience, when I first went to the court, the judgments were enormously long. And then I must admit, with President Sergio Garcia, who's over there, he worked assiduously whilst he was president with my nagging, and the judgments became shorter and shorter. But I don't know that will be kept up. And I think it is important that the panel of judges be so constituted that the judgments of the court, when they are pronounced, are readable, are understandable on first reading, because it's not only law students, lawyers, academics, jurists, and so on, who ought to read the judgment, but the petitioner themselves, the ordinary people in the communities and countries from which the matter comes, and in the general area of the Americas. And I think that's the important thing about the judgment of the court, that the ordinary people are spoken to by the court. And they cannot be, if the judgment is so complicated that even lawyers and scholars in the law find it difficult to understand what the court is saying. Thank you.
Hi everybody. I'm very shy before us today because I was thinking in my ideas in French. I have quite some ideas in Spanish, and now I realize that I must be able to present it in English. So please be cool with me. The first and most important challenge for me, from my point of view, is nowadays to reintroduce political confidence between member states and the OIs first, and second, with the inter-American system as such. How to be able to reintroduce political confidence, to which this very important challenge, I think it's very important to organize the transparency of the system. It's a very important idea that has been raised during this fantastic session between us. Transparency. First, in the domestic process of appointments of the commissioners and of the judges. To be able to put forward more female candidates, effectively, and I agree completely with Margaret, and to be able to put forward some Anglo-Saxon candidates, to be able to bridge the gap, to bridge the gap between the twofold legal culture of the inter-American system is very, very important. More transparency, and to be able to reach this challenge, organize domestic appointment more public, to be able to organize a better accountability of the judges and the commissioner. It's the first step, institutional transparency. Second step, it will be named maybe the procedural transparency. And here is a very, very important issue of the conventionality control. We all agree that nowadays the inter-American system is facing a fantastic challenge, a new kind of relationship between domestic judges and inter-American Court of Human Rights. And the conventionality control theory is nowadays very interesting, very creative theory, and it must be or the best for the system or maybe the worst. So, to be able to organize the best, the conventionality control must be very think with caution. With the Inter-American Court must think with a lot of caution the conventionality control, and the case law, the future case law must be very, very precise, more technically precise, to organize a good dialogue with domestic judges, to be able that the confidence with national judges and Inter-American Court continue to exist, because it's a key for the future, to be able that national judges accept and enjoy to implement the American Convention and the American standard.
Merci.
Thank you very much. Mi mayor desafío
My biggest challenge
es hablar ante un grupo de estudiantes angloparlantes sin ser yo angloparlante.
is to speak before a group of English-speaking students without being English-speaking myself.
El mayor desafío para el profesor Casero
And the biggest challenge for Professor Castle
es traducirme, corregirme y mejorarme.
is to translate, correct, and improve him.
¿Cuáles son los problemas mayores del sistema o el problema mayor que resume los otros?
What is the biggest problem facing the system today?
El primero tiene que ver con la democracia de los países de América Latina.
The first has to do with democracy in Latin American countries.
Hace 60 años no existía lo que hoy llamamos el Sistema Interamericano de Protección de los Derechos Humanos.
60 years ago, the Inter-American Human Rights System did not exist.
Lo que existía era un buen número de dictaduras a lo largo y ancho de América Latina.
At that time, we had dictatorships all throughout the Americas, Latin America, sorry.
Afortunadamente las cosas ya no son así y conviene que no vuelvan a ser así.
Fortunately, things are no longer that way, and we hope they never come back.
Sin embargo, hay que mantener la guardia en alto
And nonetheless, it's necessary to remain vigilant,
porque los derechos humanos solamente arraigan y prosperan donde hay democracia.
because human rights only take root and prosper where there is democracy.
Ese sería el primer tema de fondo para el sistema interamericano.
So this is the first substantive theme for the inter-American system.
Otro tema de fondo, conectado con el anterior, es mantener la integridad del sistema.
Another topic related to the first is to maintain the integrity of the system.
Y cuando hablo de sistema interamericano de protección de los derechos humanos,
When I speak of the Inter-American Human Rights Protection System,
no me refiero solamente a la Comisión Interamericana con sus 7 comisionados y a la Corte Interamericana con sus 7 jueces.
I'm not referring only to the Inter-American Commission and its 7 commissioners, nor only to the Inter-American Court with its 7 judges.
¿Qué podrían hacer 14 personas, aun cuando entre ellas haya varias mujeres, para tutelar los derechos humanos en todo el continente?
Which only comes to 14 persons, some of whom are women, and they're responsible for protecting human rights throughout the entire hemisphere.
Cuando hablo del sistema me refiero a los personajes, a los actores, a los agentes del sistema que son los estados en un régimen de garantía colectiva de los derechos humanos.
I'm referring to all of the actors who are relevant with respect to protecting human rights in the region. First, the states who have agreed to participate in a collective system of protection.
La organización de los estados americanos, que debe siempre pasar del discurso, que es excelente, a los hechos que tienen que ver con políticas y con finanzas.
I refer to the OAS, the Organization of American States, that should go beyond fine rhetoric to actual deeds and actual money.
A la sociedad civil, que ha sido uno de los grandes factores de desarrollo y éxito del sistema.
The civil society, which has been one of the main factors for for the development and success of the system.
Y a otros actores que han ido apareciendo poco a poco en el horizonte, como son las agrupaciones de comunicadores sociales, el ombudsman y los defensores públicos.
And other actors who have been appearing on the scene, such as ombudsmen, public defenders, and groups of social communication.
Finalmente, si yo tuviera que escribir una carta reuniendo todos mis buenos deseos para resolver los grandes problemas del sistema interamericano, yo seguramente pondría en esa carta el siguiente voto.
If I were going to write a letter that put together all of my highest hopes for the success of the systems, I would certainly put in this letter.
El sistema debe tener éxito en atraer más, mucho más, la presencia y el compromiso de los Estados Unidos de América.
The system should try to have more success in attracting the participation and support of the United States of America.
Por supuesto, sin perder la presencia y el compromiso de los otros estados americanos.
Of course, without losing the commitments of the other states of the Americas.
Y para ello invocaría yo la reflexión y las palabras de un estadista norteamericano.
And for that, I would invoke the words and the thoughts of a North American statesman.
Saliendo al paso de alguna pregunta que muchos de ustedes seguramente podrían formularse.
Who was addressing a question that many of you could no doubt formulate.
Atraer el compromiso y la presencia de los Estados Unidos de América, no tanto por lo que el sistema puede hacer por los derechos humanos de los Estados Unidos,
to have the United States participate in the system, not so much because of what the system could do for human rights in the United States,
sino por lo que los Estados Unidos pueden hacer con su presencia por el desarrollo de los derechos humanos de los demás países americanos.
but rather for what the presence of the United States would mean for human rights in the other states of the Americas.
Y me he pasado unos segundos, son los segundos que utilizó el doctor Carlos.
If I'm over time, it's Castle's fault. Yeah?
Thank you very much. Well, if I had to mention the biggest challenge to the inter-American system, of course there are many, but if I had to choose one, I would mention the political space in which the inter-American system works. As we discussed during the last 2 days in the closed meeting we had here, the inter-American system, the Commission and the Court are not independent bodies that work on human rights, but they are part of a bigger body, which is the Organization of American States. And unfortunately, the Organization of American States is going through a very strong crisis of legitimacy. And of course, this crisis of legitimacy affects the inter-American system, the inter-American Court and the inter-American Commission. So I think that if we want to work to support, to strengthen the inter-American system, we have also to work on the strengthening of the OAS. I think it's an inevitable link. There is an inevitable link between both or the three bodies. Trying to answer the question of what we can do, I think there are two things that we can do. First of all, is looking for a better leadership in the OAS. I think that the leadership the OAS had during the last year was not the best. in general and in particular in relation to the Commission and the Court, to the Inter-American System of Human Rights. So I really focus, or I would really work trying to get a better leadership of the OEAs. But the second thing that I think I would suggest in the line of Professor Sergio Ramirez is trying to get a higher involvement of the United States, not just of the United States, but also, the United States, Canada, and the Caribbean countries. So far, as we have discussed during the last 2 days, although we don't talk a lot about this topic, although we did it in this meeting, there are differences in the political dynamics between the Inter-American System of the OEA. There are like 3 Americas: United States and Canada, Latin America, and the Caribbean. And the role that the United States and Canada has been playing, it's not really the best. They say they have their statements in support of the Inter-American System, but in reality, it's really questionable if they really support the Inter-American System. So it would be great to have a higher involvement, a political involvement of governments of the United States and Canada, and also of Canada. And this is not just related to ratifying or not the Inter-American Convention on Human Rights, but just having really a more respect of the Inter-American System, and as I said, a higher involvement in the dynamics of the OEAs in general.
Good afternoon. It's also a pleasure for me to be here and to share with you. And in line with what my colleagues and friends were saying, I think one of the biggest challenges for the Inter-American System is how to build and increase its legitimacy. I see there like part of the knot that could unravel a lot of the problems that the system has. I think if the system could get more legitimacy, it could get more money. I think the issue of money is trivial for Latin America. We have the richest man in the world, Carlos Slim. We have the 7th biggest economy in the world with Brazil. I'm sorry. We have and if you look at the numbers of money that states put in their ombudsman's offices and the money that they give for the functioning of the ICC, the money that you need for a functioning Inter-American Commission and Court is negligible for the wealth of our region. I think the question is how are the Commission and the Court going to increase that legitimacy and that anchorage and that being a moral and a legal compass of some of the main human rights issues in our region. I think in order to do that, they need to overcome some of the divisiveness that exists in our region on some of the political issues that go not only North America and on Latin America or the Caribbean, but they go on UNASUR and the US and its vision. It goes on issues of common law and civil law. I think that the Inter-American System has to develop a legal and a moral compass that will allow it to show a better way to solve some of the main human rights problems. It did it in many instances where it helped shape and have an ultimate objective on where we had to go as a continent. And I think it can still do it, but it needs to reshape its procedures, it needs to reshape the way in which it selects the members of the Commission and the Court to have a more representative, rich, diverse body that is more connected to people. And also I think it has to create roots to people. It's not only to countries, it's not only to the executives. It includes the judiciary through conventionality control and other things, but it includes like strong roots with civil society and with people that can see that as a valuable thing, something to be proud of and a place that is a legitimate place for solving some of the conflicts and for showing a direction. And I think in order to do that, the Commission and the Court are starting in that path. I think that the whole crisis and discussions on the reform of the Inter-American system showed the Commission and the Court that they couldn't just keep on being insular and, in their thinking and talking just to a small group of people and amongst themselves about what they were doing, but they needed to find allies, they needed to show why they were relevant, they needed to talk and listen and change and do things. And so that anchorage with a broader sector of society in the Americas, I think is also key for that legitimacy that will help us move forward.
Well, as Professor Garcia was saying at the beginning, 60 years ago, 50, Latin America was full of dictatorships. And then we became part of the East-West, this bipolar and Cold War, where this Cold War left millions of victims, human rights. So the legitimacy that for us as victims has the Inter-American system is that the Inter-American system at some point recovered. Did they interpret o cómo es? Recogió los sentimientos y los sentimientos de gather the feeling of we as citizens we were ignored and that we were suffering. So that legitimacy, and that was the hope for us as victims. That is what they do. And that's the legitimacy of the Commission and of the Court. So the challenge now that we have, that the Inter-American system has, how to accomplish the judgments that they do. Otherwise, first, that the states doesn't accomplish the judgments means that no respect for the system. And us as a victim means that we are ignored once again, that we don't have rights. So, but as in the discussion we had with Professor Garcia, if the Inter-American system wouldn't raise all the human rights issues for many years, today many Argentinian generals won't be in prison. Fujimori wouldn't be, no se hubiera juzgado, wouldn't have been put on trial. Rios Montt wouldn't be put on trial. So we are walking very slowly for us as victims. If the Inter-American system doesn't survive, means that we are also losing our hope that some entity with impartiality and objectivity can say what we can say. But on the other hand, it's how to create democracy. Because today, doesn't matter if it's right or it's left, extremes se juntan, they join. And that's why it's losing the strength, the system. Because the dictatorships or the authoritarians, left or right, doesn't want to be said what they have to do in order to respect human rights. So I think that's the challenge, and that's why we were talking, how do we create democrats? But it has to be felt. And maybe before it was the human rights, life, kidnappings, and none of torture, and none of this. But today, looking at the present, there are many other challenges. And now, the new displacement, for example, is not the massacres, but it's the natural resources, how communities are being displaced, how social leaders have been disappeared, how extrajudicial killings keep going under another motivation, but at the same time, it's just the same human rights violations that we had before in our dictatorship time. So, who will represent those victims? How can we have a system in which impartiality and objectividad, those principles, the principles of impartiality and objectivity can be sustained and give a voice to those countries in which we are claiming our rights and nobody's listening because there's too much greedy in power, money, or whatever. So I think that is the challenge. The challenge is not for the inter-American system, but as Katia was saying, it's also the OAS. But if they are not interested to be democratic countries, then I think that the discussion goes por otro lado.
A different way.
Will you moderate the questions since you're up there?
Maybe we should use this for the people who are asking questions, right?
I'm not sure. But then everybody would need to stand up there to answer.
Ah, that's right, yeah. Okay, the floor is now open for your questions. I'm sorry? We have this mic here for you. It's okay. All right, you know what happens if you don't raise your hands. Yes, sir.
I guess I was wondering what the biggest obstacle or the biggest objection, I guess, the United States and Canada have in terms of ratifying and why they haven't. Maybe just the main issue that you guys think is the reason behind it all. Just want to see your take on that.
All right, would anyone like to address the question of the...
Professor Castle, can you repeat the question because it's
Yes.
recorded?
Okay. The question is, what is the main reason or the main reasons why the United States, did you also say Canada or just the U.S.?
Yes,
why the United States and Canada have not joined the convention? Perhaps, Bernard, we could ask you to address Canada. All right, I'll start with the U.S. To make a short story long, the United States signed the American Convention, Jimmy Carter did, in 1978. He sent it to the Senate, where it has sat ever since. There are many reasons for this. I think in my judgment, the principal reason is what I call superpoweritis. We don't like to submit ourselves to any international court that can tell us what to do. During the Cold War for a long time, it was Cold War-itis. We thought that the international tribunals were all tools of the Soviet Union to make us look bad. That, of course, is no longer the case. There are serious substantive issues. For example, when the United States joined the International Convention Against Race Discrimination, we refused to accept the individual complaints jurisdiction of the Race Committee for fear that that would interfere with criminal justice in the United States. They were worried that racial disparities in sentencing would be challenged by the committee, and of course the same thing would be true if we were to accept oversight under the American Convention on Human Rights. The issue of abortion is a very hot-button issue, and there's ambiguous wording and some jurisprudence from the inter-American system that is troubling to people on both sides of the issue of abortion. There's concern about what the court might do with death penalty. So there's a number of substantive issues there as well. There's much more to it than that. Add to that, finally, the fact that you need to get 67 votes in the Senate to consent to ratification of any treaty. We can't get 67 votes for the Children's Rights Treaty. We can't get 67 votes for the Women's Rights Committee. We can't get 67 votes for the Treaty on the Law of the Sea. And the American Convention does not have in this country the kind of political constituency behind it that all three of those treaties have. So there's no near-term prospects for the U.S. joining. Bernard?
With respect to Canada, Canada is a new player in the system. It joined the OAS in 1990, so it did not sign the convention. Technically, it would not ratify the convention, but adhere to it, you say in English? adhere to the convention. Yeah. The debate has been ongoing in Canada for years, and the main concerns of the Canadian government have always been the same. Essentially, the one dealing with Article 4, the right to life, and concerns related to abortion, and the others related to Article 13 and the prohibition of prior censorship. As you know, in Canada, abortion has been decriminalized. Actually, the provisions of the criminal code have been considered unconstitutional and have not been the object of a new article in the criminal code since. And there's concerns that this could be, ratifying or adhering to the convention could be instrumentalized to recriminalize abortion. And that raises concerns in the women's rights movement, of course. And the other concern deals with hate speech. The Canadian Criminal Code prevents hate speech or penalizes hate speech. So there are concerns in this respect as well. But most people who have written on this, and as well as the Senate Committee on Human Rights, have reiterated that these concerns are serious concerns, but can be addressed in various ways. The case law of the system, and looking at what are Canadian obligations that are already existing under the ICCPR, and the case law of the Human Rights Committee with regards to those two issues can be reassuring for those who have concerns with this in Canada. There's a lot to gain for Canadians for adhering to the convention and the court. It means greater protection for lots of important human rights problems that we have in Canada. We have this image that this is a country that has very few human rights problems, but it is not the case. And the second issue that's important is, as Professor Garcia Ramirez just said, this would be very useful for the entire region. Canada has been a very strong defender of the system, and when it has been pushing for certain reform, it's been a very strong advocate for human rights during the Peru crisis in 2000, when Fujimori did his autobiography and so on. And guess what the Peruvian government told Canada? If you want to tell us how to be better human rights-wise, well, start by becoming a full player and ratifying the convention. So of course this is a handicap for Canadian diplomats who want to pressure our Latin and Caribbean brothers and sisters who have perhaps concerns with human rights issues. The Canadian government always says, well, we don't want to ratify or do an adhesion with a reservation. We don't do that. Well, that's not exactly right. We did it for the Children's Rights Convention in order to be able to send kids to jail with adults. So, I mean, this is a kind of a tricky question, but I don't think there's a valid reason for not being a full player. I think it's due time that we become full players. I think it would serve Canadians, it would serve the system, and basically everybody agreed with that. The Senate Committee submitted a report in 2003 and a report in 2005. The Ministry of Justice recommended that we go forward with this, and then it blocked at some point in the process because they wanted to do consultations with the provinces, and that got lost in the process. In the meantime, there were elections, and now we have a new government that has very different positions, let's say, on human rights and on women's rights. Conservative government that might make human rights defenders who are very keen on pushing for ratification a bit less comfortable with this issue. So I think once civil society gets back on track on the agenda and starts pushing again, and I hope it will, and I'm certainly taking part in this battle in my country, I think it will be again placed back on the agenda.
Ambassador Hernandez.
I want to add a few things in order for students to get the full picture, and that is that one thing is the question of ratification or accession by Canada and the U.S. to the convention, and another issue is the question that the Commission has a jurisdiction over all member states of the organization, including Canada, the US, and you won't believe it, also Cuba. So Cuba is a member state of the Organization of American States, and the Commission does have also jurisdiction over Cuba. But here there is a different question, and that has to do with the compliance of the decisions or recommendation of the Commission by all member states. And I find that there are different degrees of observation of the rulings of the Commission among the 35 member states. One of the things that, from the Mexican point of view, we also see with a little bit of reluctance, with a lot of skepticism, is the compliance by the US to the Commission's decision, regardless whether the US is a party or not to the convention. One specific example. Several times there are petitions from defenders of Mexicans in death row to suspend the execution of a Mexican national because they are covered by the Avina ruling of the International Court of Justice, and nothing happens on the US side. There is not the minimum respect for the provisional measures issued by the Commission, and that sends exactly the wrong message of compliance and respect by the US to the Commission. I cannot tell you what would happen within Mexican society if the Mexican government does not take seriously a decision by the Commission with regard to provisional measures. That could create big political problems inside Mexico if we neglect provisional measures. That could create a lot of political pressure in the Organization of American States and in the Commission if Mexico does not abide by any single decision of the Commission, whatever it could be. That doesn't happen with the US, it doesn't happen with the US government, and very frankly, there is not a sufficient knowledge of the work of the Commission in the US civil society. So those things happen. Those things happen without being noticed in the public opinion when a decision of provisional measures against protecting Mexican national network that's completely get out of the picture.
Thank you. Further questions, and you may feel free to address either one of the panelists if you have a question about what they addressed, or the panel in general. Yes, Father Joe.
The Inter-American system. Let's just go back to the Organization of American States, 1948, and today it's 2014. Is it your sense, any one of you, just one, not many, because probably we don't have the time, but just one of you could respond to this. So much time has passed. Are we at the threshold of revising the whole system? I mean, the dictators are gone. The instruments probably need to be revised in some way, substantively, procedurally. Are we at the threshold of revising the entire system in some way? As the dictators are mostly gone, we probably now would be looking at a point at which we could be looking at, say, for instance, the European system, and because probably there are not as many dictators, and probably in Latin America too, there are fewer and fewer dictators. Are we at a time when we can think of revising the entire system substantively and procedurally?
The question notes that decades have passed since the institutions and instruments of the inter-American system were designed. Dictatorships are almost entirely a thing of the past at this point. Is it time for a major overhaul, a major reform, revision of the instruments and institutions of the system? Are we at such a point? Any member of the panel is invited to respond, Vivi.
estamos ya en condiciones de reformar los instrumentos y instituciones del sistema, visto que los instrumentos son antiguos y ya no contamos con
No sé por qué me arrojan esta pregunta a mí.
I'm getting this question.
Creo que sería una pregunta más bien para la sociedad civil que para un antiguo profesor.
The judge thinks, as I do, that it's a question for civil society. In other words, Vivi. But
no le oí bien la pregunta, estaba tratando de entenderla, pero no le oí bien.
Well, at first, the question.
Que siempre estamos reformando el sistema.
Reforming the system.
No necesariamente lo estamos haciendo a través de nuevos instrumentos flamantes, totalmente distintos de los anteriores.
We're not necessarily coming up with radically new instruments.
Estamos haciendo como los Estados Unidos reforman su constitución a base de jurisprudencia.
The way the United States reforms its constitution on the basis of jurisprudence.
Todos los días hay nueva jurisprudencia de la Corte Interamericana.
Every day there's new jurisprudence from the Inter-American Court.
La Corte Interamericana en sus 30 y un poco más años de vida,
in 31 years of existence,
ha conocido un número relativamente pequeño de casos.
The Inter-American Court has heard only a relatively small number of cases.
No son 200.
More than 200.
Y en cada uno de ellos ha dado algún paso adelante con base en la misma convención, interpretada con los ojos de hoy, no con los ojos de 1969.
In each case, it's taken a step forward in interpreting the American Convention, not seen as it stood when it was written in 1969, but looked at through the eyes of today.
Esto no quiere decir que no podamos, debamos y queramos hacer reformas mayores en el sistema.
This doesn't mean we shouldn't make more important reforms in the system.
Pero tenemos que entender que estas reformas no necesariamente pasan por un cambio de la Convención Americana.
Reforms don't necessarily imply reforming the American Convention on Human Rights,
sino por una serie de cambios administrativos, normativos y de actitudes.
A series of changes, administrative, normative, and attitudinal.
En todos estos actores del sistema a los que me referí.
Among all the actors in the system to which I referred earlier.
Los estados cumpliendo sus constituciones sin necesidad de reformarlas.
States complying with their constitutions without the need to amend them.
La OEA acentuando sus políticas y otorgando recursos financieros suficientes sin necesidad de modificar la Carta de la OEA.
The OES carrying out its human rights policies and providing adequate funds without the need to revise the OAS Charter.
La Corte y la Comisión modificando sus prácticas y sus procedimientos.
The Court and the Commission modifying their practices and procedures.
Todo eso lo podemos hacer.
We can do all this.
No es sencillo.
It's not simple.
Pero lo podemos hacer.
But we can do it.
Y de hecho existe, según mi percepción, un gran impulso hacia la reforma del sistema por distintos motivos y con distintos destinos, pero existe un gran impulso y se está paulatinamente dando. Cuidado, sin embargo, cuidado con intentar reformar el sistema dando pasos hacia atrás.
There is a big push to reform the system. It comes from different directions. It pursues different objectives. We have to be careful that the reform doesn't result in taking a big step backward.
Esa es mi respuesta y cedo el micrófono a mis shakespearianos compañeros de mesa para que continúen respondiendo.
The microphone to his colleagues at the table. Would you like to add anything, Vivian or Katja? How good of you to volunteer.
That was a wonderful, perfect, so well-rounded response to your question. And in deepening what the Mr. Garcia Ramirez said, the Inter-American Commission, when we had dictatorships and authoritarian governments and civil wars, the Commission, if you look at its history and its practice, used to do a lot of reporting and on-site visits, and it used all these promotional protection tools to address gross violations. And then in the 90s, when most of the civil wars ended and most countries had already started in their path towards democracy, imperfect democracies, but democracies, electoral democracies, the Inter-American Commission and the Inter-American Court started developing more of the individual petition mechanism and addressing some of the structural issues that still prevail in the region through the case law, and adapting some of the jurisprudence and the remedies, if you look at all the theory of remedies, to also trying to address with a different tool some of the pervasive problems that still plagued Latin America primarily. And the political organs of the OAS also moved on different fronts. So, for example, we had a set of new treaties on specific topics. We had the first treaty on violence against women in the world. We have new treaties on discrimination and racism. So the system has changed dramatically from the 1950s to nowadays. There has also been a development of a collective guarantee for democracy that doesn't work, but it shows that there's a concern and a recognition of democracy, you know. So, and there's a lot of room for improvement. And I think one of the keys to that improvement is how to keep that spirit strong and be able to change in a way in which it responds to what Helen was saying about really keeping that integrity and being that moral compass and giving hope, and but not with the same mindset. It cannot be the same mindset that when we had dictatorships, and there's a new world, and so we also have to connect with people, and the Inter-American system has to make a strong point of connecting to victims and the judiciary and all.
Thank you. Thank you.
Mustafa.
I have a question for all the panelists, actually. I can understand that the Anglo-Latin divide in the jurisprudence of the court and its procedural work can be actually bridged and linked throughout the years. But with regards to the ongoing political confrontation between, safe to say, the Bolivarian states from one side and the relatively democratic states or the democracy champions of the other member states in the OAS, how do you think this would impact the work of the court and the commission as well? And do you think that the best way of approaching this confrontation is to appoint a new political leadership in the OAS, or is there any other way that you might think can be actually valid in that sense?
The question has to do with the geopolitical conflict in the Americas right now between the so-called Bolivarian states, Venezuela, Ecuador, Bolivia, and Nicaragua at a minimum, and the champions of democracy in other states of the Americas. How is that affecting the inter-American human rights system? How can it best be addressed in a way that protects human rights? Is the way to do that to select new leadership for the OAS? And the question is addressed to any member of the panel who wishes to take it on, perhaps. No. Katia, you're up.
Bolivarian states are the main problem. I think they are part of the problem, and I don't think the other states are the champions of democracy at all. I mean, many of those states are part of the problem. Many states, on the right, social democrat states that are left-leaning, they do not like international supervision. It runs much deeper than pro-democracy, anti-democracy divide. And also, I think that many of the Bolivarian states, and I'm not, profoundly Bolivarian or anything like that, but I understand UNASUR and the whole geopolitical movement of that. They are trying to make important strides in securing rights for people, and they're making many mistakes. But I wouldn't make them as well the anti-democratic. I wouldn't consider them the anti-democratic states or label them as anti-democratic states.
Yeah, one thing related to what Viviana said, and the question which was raised before. This is the key topic: the geopolitical changes in the region and how they are affecting the OEAs and the inter-American system. So one thing that I want to say is that I do believe that any institution has the right to recreate itself, to change, to reform. That's fine, and this is answering the question raised earlier. But the risk here is that several states are promoting or encouraging changes, not because they want a better organization, but because they want to not have an outside control. They say, well, we are democratic countries, so we don't need any international supervision. This is what is behind this reform intent. So, I agree, I firmly believe that any institution has to think has to be always thinking in reforms, improvements, and this is why we were here during the last 2 days. But we have to be very cautious about what is behind the intention of reforms. And this is related to the other question. It is clear that there are very important geopolitical changes in the region, and this is why ALBA countries are here. Canada, Brazil, for example, the role of Brazil right now, it's very strong. There are already people who are thinking that why don't we just keep UNASUR and CELAC and Mercosur? We don't need the OEAS. The OEAS doesn't do anything. It's irrelevant. So there are already people saying that, even movements saying that. I think that the OEAS, with all its problems, is the only space where you can find all countries of the Americas, the big and the small. And now, if you see to UNASUR and Mercosur, particularly UNASUR, it works because it is made up by friends. I don't know what's going to happen in 10 years with new governments. So somehow, with its problems, the OEAS, it's the only place where everybody is there, and there is a possibility for the Caribbean to talk to the biggest one, to Latin America to talk to Canada and the US, and UNASUR, I don't know, somehow I think it's great to have other bodies, it's great to have other forums to discuss these topics, but again, we have to be very cautious what intentions are behind these ideas to just keep UNASUR and CELAC and finish and close the OEAS.
I think we have time for perhaps one more question that may have multiple answers, and then I'm going to give those members of the panel who have not spoken in answer to questions an opportunity to have a final word or two. Juan Pablo? Yeah. Maybe we'll have two more questions. Depends on the length, long way. Juan Pablo?
After what happened in Brazil some years ago, how do you think that what is happening in Colombia now with regards to Petro's precautionary measures is going to impact on the future of the precautionary measure system?
You'll need to give a little more background than that, because most people here don't know what you're talking about.
Maybe I need translation.
All right. Well, I'll give a minimal introduction. The question is, what is the challenge to the system right now with regard to precautionary measures in the case of Colombia, following a situation where the Commission a few years ago issued precautionary measures against Brazil, requiring that Brazil cease the construction of a major hydroelectric project that was the top priority infrastructure project of Brazil's President Dilma. And Brazil responded to those precautionary measures by refusing to halt construction, indeed by accelerating the licensing process, withdrawing the Brazilian ambassador from the OAS. Brazil still has no permanent representative to the OAS, temporarily withdrawing Brazil's funding for the system, etc. And now Colombia is challenging the Commission on a matter of precautionary measures. How serious is this impact likely to be? Who would like to take that question on? Vivi?
No.
You
it's just that I've been involved in this issue, and some of you know. And so I'm not the representative of Petro, but I've made public statements about this issue. The government of Colombia decided not to comply with the precautionary measures through a statement that the Chancellor issued that it hurts a lot the whole system of protection of human rights, because it states different things that are wrong under international law, or at least questionable based on the practice of Colombia, such as that precautionary measures are not binding to Colombia, that they never were binding, that they can only be issued on issues of physical integrity and life, and that the Commission was being prejudicial, and that they were acting in breach of their own rules of procedure. So it is a very, very serious set of reasons that they gave not to comply. They also didn't go to one of the hearings at the Commission, neither went to the hearing the Ecuadorians and the Bolivians. The Ecuadorians, because they had another a precautionary measure on an issue of freedom of expression that they felt uncomfortable with, and so they decided not to go to the hearings. And then the Bolivians didn't go to their own hearings in solidarity with the Ecuadorians, which is kind of funny. So it's been really tumultuous the last week. And I think it goes to the legitimacy of the system, and so how some right-wing governments, or I don't know, like I consider the Colombian government a right-wing government, and the right-wing governments are also undermining the system. It's not only Ecuador, it's not only Correa, it's Santos, who we thought was very serious about the peace process and all this. The legal issues behind the case of Petro are complex. We've written profusely about the topic in Spanish, and we have some things that we circulated in English. If you're interested in reading that, I brought some of those things here. But I think at the heart of the question was the issue of how fundamental it is to be able to participate politically when you are trying to come to government with a leftist ideology and carry out a leftist program. And I know that all of this sounds very bad in English because this country doesn't really like the word left, but a progressive, this guy was trying to do a progressive government, and what happened was that through an administrative decision, the general prosecutor, attorney general, like some type of administrative thing, is not even a prosecutor or nothing that equates with a criminal proceeding, decided that for negligence in the handling of the trash, I don't know, like garbage for 3 days, the collection of garbage for 3 days, and breaching the principle of free enterprise, the mayor of Bogota, that had been elected by thousands of people, had to be fired and also prohibited from exercising any political position for 15 years. So is so arbitrary, is so absurd. And this happens in the context of a peace process where you want to, in a country where thousands of people have been killed after being demobilized and for participating with a left-leaning ideology. And so this, to many, is a message that shows that there's no space for political participation from the left because you're going to be either killed or unfairly prosecuted or dismissed from office. So it has a lot of consequences for the peace process. So this is very troubling to all of us, and the position of the government in this context, dismissing the inter-American system and its own precedents and the rulings of its own constitutional court for political gain has been so shocking that have some of my most vocal and articulate Colombian friends becoming mute out of absolute desolation and mistrust. They are having a profound mistrust now on democratic institutions, and I think that saddens me horribly. So.
Thank you, Vivi. We have time for one more short question. Is it directed to one person, Wambui? Oh, I'm sorry, Wambui. I'm just informed that Sarah's been trying to get the floor for a while, and my left eye is not so good. Is it directed to one person, Sarah? Good. Please go ahead. To Judge McCauley.
One justification that I've heard for not being so concerned about having a more diverse bench is bias. So the hypothetical that was given was that a judge who's a woman might be more biased when it comes to women's issues like gender-based violence. And I think it could also go for indigenous people's issues. So I was wondering if you could speak a little bit more about the benefits of having a bench that more fully reflects the population that it serves in terms of bias.
The question is about what are the benefits of having a bench of judges who are more representative of the population they serve, particularly with regard to gender. Does that lead to some sort of bias in the decisions of the court? Where's the mic?
Well, personally speaking, it does not. I have a background, apart from being a private practitioner, which makes me completely independent. I serve my clients, whoever they are, and however ugly they may be. But I also have a background in women's rights movement and children's rights movement. That did not bias me in favor of women. What it did is it made me sensitive to recognize issues which relate to discrimination and abuse of the rights of women, which the court, until the latter years, did not have a good record for. In fact, before the 2002, I believe it was, cases went before the court when women were raped and so on, but they never dealt with it because there was nobody there who recognized this as an issue which ought to be dealt with. So clearly you have to have, to my mind, if you're going to have a really strong court, you must have a court full of persons who are knowledgeable and sensitive to issues of human rights which exist, because that's what the court is there for, to lend an ear and protect and remedy violations of human rights of persons. And certainly women make up 51% or 52% now probably of the world's population. So there can be absolutely no reason why women should be kept off on the spurious ground that they would be biased towards women. And that has not happened. We did have 3 women at one time, and it was the strongest court, in my view, that we've had.
We're almost out of time, so I'd like to offer the floor to Laurence and Helen, who have not had an opportunity to respond to questions, in case there's anything you'd like to say about any topic that has arisen since your opening remarks. Well, do we have time to go for one more question also?
Sure.
We do? Okay, Wambui, you're in. Go ahead.
I guess given the fluid nature of the inter-American system where you do both promotion and protection, and with a limited funding, do you feel one deserves prominence over the other, or should they be?
The question has to do in a system that has limited funding and a mandate to do both protection and promotion of human rights. Should one have priority or preeminence over the other? Who would like to address that? I think that should be someone who's spoken before.
El tema es promoción y protección. Es un poco difícil decir cuál tiene prioridad, porque van las dos cosas juntas.
Say which should have priority because the two go together.
Al proteger, promueves.
You protect, you promote.
Previenes y por tanto proteges.
And when you promote, you prevent, and therefore you protect.
Si se hiciera una prioridad, lo que ocurriría es que se ahorraría dinero en uno de los dos aspectos para gastarlo en el otro.
If you tried to give priority to one, you'd end up saving money on one of them in order to just spend it on the other.
Esto sería muy desaconsejable. Es como decir que va primero, que los jueces y comisionados se trasladen al lugar de su trabajo o que se pague la renta de sus locales.
He says it would be inadvisable. That would be like saying that what?
Los jueces y los comisionados a sus trabajos cuesta. Y también cuesta que se pague la renta de sus locales. ¿Qué va primero?
Which, it's like asking, which should you do? Should you pay the judges and commissioners to go work, or instead should you pay their rent?
Tienen que ser las dos cosas.
You have to do both. You can't divide it up.
Sería peligroso y nocivo hacer una prelación entre ambos conceptos de gasto.
Prejudice and negative to try to make a selection between the two. And
es importante que los estados paguen sus cuotas.
Is that the states pay their dues to the OAS.
Para que alcance para ambas cosas.
So that they can do both activities. And with that, I once again want to offer the floor briefly to Helen or Laurence if there are any closing remarks you wish to make. Helen?
Maybe I want to complete the question you answered. Once again, for me, the challenge is if the majority of the countries are really Democrats or not. Because what we're talking about is about protection of life and promoting it. And the Inter-American system has, during these years, saved a lot of lives through the medidas cautelares y provisionales, by the precautionary measures and provisional measures from the court. So that is important because, at least for the citizens, sometimes you take the state as your enemy because the state sees civil society as the enemies. Doesn't matter if they're socialist or they are well, in both cases can be authoritarians. So I think that that's why the challenge has to be, are we really Democrats? The countries are really Democrats or not? There is no, in the political system, you have dictatorship or Democrats. But you don't have an un sistema intermedio.
System.
And where is the transition? Where do you go to this? And for me, democracy is also a lifestyle. And to live in democracy, you need education, you need health. And developing countries doesn't have neither education or health or whatever you need to, because we're trying to survive. So survival, it's because the people react in order to survive, and then the others that, one of the conventions that was also signed by was the corruption convention, ¿no? Because eso, la corrupción lo que hace es erosionar las bases del Estado de Derecho.
Corruption undermines the basis of the state.
males de América.
That's one of the great evils of America, Latin America.
Que también viola y mata los derechos humanos.
Results in deaths and violations of human rights.
Se muere mucha gente de hambre y mucha gente de enfermedades.
Because of corruption, many people die of hunger and many people die of illness. Well, I have three final words. First of all, thank you all for attending. Secondly, we have a reception in the hallway right outside after the event. And thirdly, please join me in giving a round of applause to our guests.
Thank you.